Well, good morning, ladies and gentlemen, guests and distinguished panelists. I would like to welcome you to the Civil Asset Forfeiture Summit. My name is Sekemia Mwonyonyi. I am the Deputy Director of the Coalition for Public Safety. That is a coalition here in DC, which we're lucky to have Americans for Tax Reform and Right on Crime as partners. We have a very, very great morning planned ahead of us. I'm honored to be the host here today. I personally want to express my gratitude to the Americans for Tax Reform and then its visionary president, who we have as one of the panelists, Mr. Grover Norquist, for convening this today. And I also like to express my gratitude to Right on Crime, who's jointly holding this event today. This is an important subject for all Americans, that is civil asset forfeiture. Let me give you sort of a lay of the land of where we're going this morning, so sort of sketch out of what you're expected to hear. We have two panelists scheduled for today. Seated is the first one. The first panelist is going to sort of discuss what's the problem. Sort of what is civil asset forfeiture, discuss some of its excesses, perverse incentives that it has, the impact on the innocent owner and the average American family. The second group of panelists are going to sort of more or less discuss solutions, different policy ideas to help modify civil asset forfeiture. So I want to first recognize the first moderator for our first panelist, and it is John Malcolm. John Malcolm has a very, very long legal background spanning different cities, different states, different contexts. He currently is the director of the Edwin Meese Center at the Heritage Foundation. He's as well the Heritage Foundation's Gilbertson Senior Legal Fellow. He's also the chairman of the Federalist Society's criminal law practice and has done many things prior to that. I would like to personally point out that he also was a prosecutor in Atlanta. So he definitely has a background in law enforcement or working for the government, so he can certainly speak with authority on these things. With that said, let me turn it over to John Malcolm.
Well, thank you. I mean, I guess my long and varied career comes with the inability to keep a job. So just to sort of set the stage, so civil asset forfeiture, it's based on a fiction. And the fiction is that a property can be guilty of a crime and therefore forfeited to the sovereign, regardless of whether any individual is ever charged with, much less convicted of, a crime related to that property. Forfeiture law in this country is an ancient lineage. It dates back to the 18th century maritime law. The first Congress put civil forfeiture in place in order to enforce customs duties when ships were seized and the ship or cargo owner was outside of the reach of U.S. courts. Forfeiture law was very quiet for a long time. It had a short blip during Prohibition and then went quiet again. But Congress found new uses for civil forfeiture in the 1980s as part of the war on drugs, targeting the assets and profits of drug dealers, drug kingpins, and drug organizations. Since then, civil forfeiture has expanded dramatically. It now encompasses more than 200 federal crimes and a whole host of state crimes, and that has resulted in billions of dollars in seizures. Now, civil asset forfeiture has a laudable goal, and that is to deprive criminals of the fruits of their illegal activities. However, the procedures used in order to do this are often skewed against innocent property owners. Indeed, suspicion alone is often deemed sufficient to strip citizens of their homes, their cars, and their life savings. So long as law enforcement officials allege that the property was used in the commission of a crime or represents the proceeds of a crime, it can be seized, even if there's no probable cause to believe that the owner of that property was in any way involved in the alleged illegal conduct. To win seized property back, innocent owners have to navigate through a tortuous legal system that is often stacked against them. There's no presumption of innocence, no right to counsel, Many forfeiture cases, in fact, never end up seeing the inside of a courtroom. And in order to prevail, the property owners, in effect, have to prove that they were innocent. Now, in addition to that, most of the forfeiture funds end up back in the coffers of the very law enforcement agencies that seized that property in the first place. And it is this direct financial stake in the size and scope of the forfeiture process that has led some to refer to civil asset forfeiture as policing for profit. We have an excellent panel here assembled as this first panel to discuss some of these issues and to answer some of your questions. Let me briefly introduce them. The introductions will be way shorter than each one deserves. To my immediate right is Jason Pye. He is the Director of Messaging and Director of Justice Reform at FreedomWorks. Prior to joining FreedomWorks late last year, he worked as an editor of United Liberty, which is a blog devoted to free markets, individual liberty, and limited government. He was a finalist for the Atlanta Press Club's Award of Excellence, and his postings on a variety of topics are widely read. Next to him is Grover Norquist, whom, as you all know, is the founder and president of Americans for Tax Reform, an advocacy group that opposes higher taxes and seeks to limit the size and scope of government. Every Wednesday, now for decades, Grover hosts the Wednesday meeting right here in this very room, at this very table, which is attended by elected officials and political activists of all stripes. Grover has also served, or continues to serve, on the board of directors of a number of prominent organizations, including the American Conservative Union and the National Rifle Association, and he is also a signatory of the Statement of Principles of the Texas Public Policy Foundation's Right on Crime initiative. To my far right is Walter Olson. Walter is a senior fellow at the Cato Institute's Center for Constitutional Studies. Prior to that, he was a senior fellow at the Manhattan Institute. Walter is the author of 4 books, and his articles have appeared in prestigious publications around the world. He was once dubbed the intellectual guru of tort reform by the Washington Post, and he's testified numerous times before Congress and is a regular commentator on radio and television. So please, let's take a moment to join me in welcoming our panelists. So let's get started with this discussion. Jason, I'm curious about, and then we'll go down the row, about how you and your organization chose to get involved in this particular effort in order to reform civil forfeiture laws. Here.
Oh.
There we go.
Thanks. For us, I guess. For us, it was Matt Kibbe. He got involved in he drug us into the Coalition for Public Safety. I say drug in this hot mic. I say drug, I mean that in like the kindest way possible. But we started talking about it in October or November of last year, and he was telling us how, just basically how, he just sat down and said, look, this is a civil liberties issue, it's a due process issue, it's a property rights issue first and foremost. And last weekend we had 55 activists in our office. Okay, I'm just going to turn this off. Had 55 activists in our office from 15 states. And we were just explaining them like some of the issues surrounding our justice reform project. And I was kind of real hesitant because they're mostly conservatives, and I was real hesitant to say, like, be perceived as beating up on police or say anything negative about police. And I was kind of surprised.
If we have one on at a time, I'm told it works better.
Okay.
So the rest of us should keep ours off while you're
Okay.
See if that helps. And John, that means yours too.
Okay.
I was kind of surprised to hear our activists, several of them who I had conversations with them, they were very conservative, and just basically saying, this is, like, why are these, like, the people who do this, the policymakers who advocated for these laws, the police officers who do this, like, why aren't we, like, prosecuting them? I was really kind of taken aback by it, because we're not advocating anything like that or even suggesting that. But that's kind of like their take on this. It's like, this is legal plunder, this what they're doing is wrong, and we need to fix this. And they bought into everything. And what we're doing to talk to our activists about this is, recently FreedomWorks put out a publication called Civil Asset Forfeiture Grading the States. It's very similar to IJ's report from 5 years ago. And we went through and graded all 50 states, their civil asset forfeiture laws. And I have some of the details here, but if you guys would like a copy of this, I'll be happy to email one to you. See me, I'll give you a card later. But the details are this. We have 2 A's, New Mexico and North Carolina. 7 Bs, most recently Montana and Minnesota and Washington, D.C. 13 Cs, it's an average grade. 20 Ds, 15 received a D minus. 9 Fs in the federal government, we gave them a D minus. And we graded on different scales. It was, what's the standard of proof the government must meet to forfeit a person's property? Who has the burden of proof? And what percentage of forfeiture funds are retained by law enforcement? And it was, I think 30 states, they keep at least 50%. I think it was 14 keep 100%. So the profit motive is obviously the biggest driver there. But I don't know, for us it's a property rights issue, it's just a due process issue. It's fixing bad laws, bad policy, and I would just been kind of surprised to see how our activists have just kind of like embraced this issue.
I noticed that your 2 A's, by the way, those are the 2 states that require a criminal conviction before you have
Yes.
any kind of civil forfeiture. So, at least for that standard, that's how you get an A. I suppose.
Well, I mean, close enough. I mean, Montana also doesn't have a criminal conviction, or they also require a criminal conviction, but they have other problems in there, like the profit motive exists, and the burden of proof is, well, criminal conviction is actually not that big of a problem anymore, but we gave them a B. There was a couple other things. I'll have to go back and look and see specifics.
Grover, how did you come to get involved in this particular issue?
I remember we were fighting on this in 2000 when we got the Hyde reform passed, and I was under the impression we'd fixed it back then. And there was some progress made, but there was this vast expansion of forfeiture in the 80s because people were watching Miami Vice and felt we had to do something because all these criminals had nicer cars than we did, and nice houses and the cool boats. So anyway, so he passed the Miami Vice law, and then it turns out it doesn't just affect Colombian drug dealers, but other people. So there was this effort, which culminated in 2000 with the Hyde's reforms, but that wasn't enough, and it was federal, not state. In taxes, the way politicians get to tax everybody is they do trickle-down taxation. They say, we're only going to tax rich people. This is the federal excise tax to pay for the Spanish-American War. It was a tax in 1898 because only people who could afford a $5,000 phone at the time were paying it. It was for long distance. So don't let this bother you. We're just going to tax rich people who can afford $5 in today's dollars phones. And very few people did, and over time everybody had a phone and prices went way down, but the 3% federal excise tax was everybody. So taxes trickle down. They do the same thing with asset forfeiture. They assert to you that they're only going to go after bad guys and so on. But that's not what's actually written in the law. And it trickles down to hit all sorts of people. I remember seeing this when the rental car companies pointed out they had a problem because smart drug pushers, or whatever word, renting their cars, because if they got arrested, the car that got taken by the government belonged to Hertz. And Hertz was going, hey, what happened? What did we do? And they had criminal cars and they didn't know it. They should have done, checks before they bought the car to know it was a bad car. Yeah, bad car. No, my customer knows the car that was the criminal.
Yeah.
So this has been a recurring challenge, and again, it follows into, they demonize some person, group, entity, get you all concerned about a crime. This is going to help us fight that. But then the door they open is way beyond solving that problem or targeting those people. It goes to everyone. And even if you were just targeting ex-bad guys, you should probably still take the Constitution into consideration. So the whole idea that this is assault on property rights, that this is taking something that people agree to, an extremist, and then somehow it slides into we just see that on the tax front as well. So I just think it's a big issue. I also like the fact that it unites folks on the right and the left, and it's one of those issues for the next several years that we can get something done. Because in Washington you have a Republican House and Senate, Democrat president, nothing moves for the next 2 years, nothing big, right? They can't raise taxes, we can't cut taxes. But this is one of those issues where I think we can get actual movement and we can focus on it, because you could see something pass. You could see the president sign something that a Republican House would pass, and that's certainly true at state level too.
Walter, how about you and Cato?
Cato goes way, way back on this issue. We published a book in 1995, 20 years ago, with then Congressman Hyde, who was leading the reform efforts. And for Cato, it's a natural, because it involves the individual against the state, issues of due process, property rights are very important to us, and the drug war, which Cato has been critical of since the start. My path to it was somewhat different because I've been at Cato for 5 years. Before that, as John mentioned, I spent 25 years kind of on the trial lawyer's case. Prosecution for profit is a very meaningful phrase to me, because if you ask what's wrong with civil litigation in the US, part of the answer is that much of it goes on propelled by lawyers who are getting 30% or more or less of damage awards, and although there are many very honest and very capable people doing that, the incentives will distort the handling of evidence, the handling of witnesses, the overcharging of otherwise legitimate cases. It distorts a lot of things. Now, what I tell people now is, if you're afraid of a private trial lawyer getting 30% with only civil charges to throw at you, please start worrying about someone who has all the power of the state as a prosecutor, might be getting 100%, and is not limited by the limitations that we apply to the powers of private lawyers. So prosecution for profit is a phrase to bear in mind. It is a corrupting thing to do to any legal system, and I think that Cato has been pointing that out longer than everyone else, but it is so satisfying to see a large chorus behind it now.
From Heritage's perspective, I think I'm back at yes. From Heritage's perspective, certainly everything that was mentioned here in terms of property rights being very important. However, we take a very hard look at the criminal justice system. Sekemia mentioned that I was a prosecutor in Atlanta for 7 years, an assistant U.S. attorney. I was also then a deputy assistant attorney general in the criminal division during the George W. Bush administration for 3 years. And look, I'm very much in favor of law enforcement being adequately funded and getting to do their jobs, but just as we, for very good and sufficient reasons, put law enforcement officials to have to jump through hoops before somebody can be thrown in jail and deprived of their liberty and labeled a convicted felon, the same sorts of fair procedures ought to be in place before people can be deprived of their livelihoods, particularly if they are never going to have an opportunity to go into court and really say anything. And the procedures are dramatically skewed, in my opinion, against the individual. And profit motives are also very important. So we've each sort of touched upon how we got involved in this issue, and there are many things that one could say about civil asset forfeiture. I'm curious whether you have a particular thing about this, that, this whole procedure that troubles you the most, and if so, what that might be.
I think for us, it's the burden of proof. We've been taught our entire lives that you're innocent until proven guilty, but civil asset forfeiture, that just doesn't exist. You're guilty until proven innocent in most states, and it's just that inversion of justice. I think is the thing that troubles me the most. But also, but with that is also the profit motive. But yeah.
The incentives that are set up, we see this in Ferguson and the reaction out there, that the amount of money that the police were getting for speeding tickets and so on. And the one reform that actually happened out of Missouri was that towns can only make 50% of their total income from speed traps. Somebody told me they may have actually gotten that down to 25% at the end of the day in the Missouri law that came out, but 25 is pretty high too. And that was the reform. That was the reform, not what was happening. The idea that you give police an incentive to go out and grab stuff is extremely dangerous, and criminalizing stuff. The old Roman dictator Sulla, when he was prescribing people, he'd have people prescribed and then killed, and then their property came to him. And so the people would say he was killed for his villa. The crime was he had this nice villa. And now you've got police and others that want property or cars or money, and you've set up this very bad incentive that just leads to abuse. If the money just went and sat in a corner, went into the general fund, it would tremendously reduce the incentive to misbehave. I mean, it still shouldn't happen. But if you could take away that incentive to begin with, it'd make the rest of the reform a lot easier, and I think you'd have a lot less abuse.
Walter?
Jason and Grover have, of course, brought out a lot of points I would, but let me add one or two, because when a forfeiture happens, particularly of the most valuable property someone may own, someone's house is seized because their son is believed to be dealing pot, or someone's car is seized who doesn't own much more than a car. What you have done, you not only have a conflict in which the government has much more power, but the simple ability to go out and hire a lawyer may be compromised by the fact that they've got your most important asset. You may be losing your other assets because of your inability to get to work or to manage the crisis that results from losing the main one. Small businesses face this constantly, and as we'll talk about, small businesses face a lot of forfeiture law. So you have this imbalance, which the courts have done a very poor job of addressing. There was a Supreme Court case involving whether or not there was a right to hold back funds, which did not go the right way. But to make it all worse, you have the opacity of the process, the difficulty of getting information from the outside, and I believe this is one of the reasons why it's been going on 25 years, but until fairly recently, when groups like Institute for Justice began focusing laser-like on finding individual horror stories, it was very hard for those horror stories to filter out to journalists and policy types who had less of an intense interest in the question. Why was it so hard to filter out? Well, partly because the cases settle. We know, as in criminal law with plea bargains and as with civil law with settlements, the great majority of cases end up in an agreed settlement, and the agreed settlement includes don't squawk any further, this is the end of the case, don't try to get your property back by setting up some collateral proceeding. And we now know from some of the cases surfacing in the last couple of years that it's even a little bit more intense than that. It happened in one of the Maryland cases that I wrote about, where the lawyer was hinted out that he was going to get a less good case for his client because they had gone to the press. And it also happened in IJ's case in North Carolina of the convenience store owner who had $107,000 grabbed from him. And IJ actually saved the email. I'm glad they did. Your client needs to resolve this or litigate this, but publicity about it doesn't help. It just ratchets up feelings in the agency, unquote. And people don't dare to talk.
Was that a structuring case, by the way?
Yes, that was
You want to talk a little bit about, because you mentioned small businesses, and
right.
some of this is tied up in structure.
Both of the cases that I was just referring to are structuring cases, and this fascinates me.
Right.
For those of you, for those of you who have not been following structuring law lately in the news with Dennis Hastert and before that with Elliot Spitzer, it was made illegal some years back to engage in bank transactions of less than $10,000 for purposes of not having the paperwork filed that gets filed when you have cash transactions of more than $10,000. And the banks are forbidden to tell you that this is the law so that you can more easily get caught in the net. And caught in the net are not just some drug dealers and other people who know perfectly well that they're violating the law, but a lot of small businesses that deal in cash. And the first one that I wrote about at length in my own Frederick County, Maryland, which has several representatives here, was a dairy farm that sells ice cream at a lot of farmers markets, does a lot of cash business, and found its bank accounts frozen by the government. But this goes on with a lot of different small businesses that deal in cash, used car dealers, and the sort of grocery stores and convenience stores and small restaurants that IJ has been representing recently. The law is outrageous enough, but the idea that it is being used to grab money from those who were not concealing any underlying illegality, and typically in these cases, there is no accusation even that they were evading taxes. I don't know, we probably have mixed opinions about how bad a sin that is in this room, but you can understand the rationale if it's to conceal genuinely illegal activity, but it isn't even that. You can lose the money, though you weren't concealing anything unlawful.
Yeah, no, structuring is considered in and of itself a crime, regardless of whether the money that you were depositing was ill-gotten gains, and regardless of whether the money you were withdrawing was to be used for an illegal purpose. It is a separate offense. Those are all great. Let me highlight just a few other things that have sort of stuck in my craw. One of them was mentioned, which is the total lack of transparency that's involved in forfeiture funds. I mean, usually, and I fully believe that law enforcement agencies, have a very, very valuable role to play, and they should be adequately, indeed generously funded, but they should be funded through the general appropriations process. Forfeiture enables them to, in many ways, determine the scope of their own budget and is totally outside of the appropriations process. No oversight, no insight at all into how those funds are used. Oftentimes they're used for legitimate law enforcement functions, however, oftentimes they are not. I would also say that in addition to the lack of transparency and the unfairness of the procedures, it really gives law enforcement tremendous leverage. So for instance, a lot of the structuring is terrible too, but a lot of these seizures take place, for instance, for cars that are stopped on roadways. And the police will come along and they'll start engaging you in conversation, and lo and behold, it comes out either through a consent search or conversation that you happen to be carrying a large amount of cash. You might be carrying that cash for perfectly legitimate reasons. And law enforcement officials will sit there and say, well, gosh, you're an out-of-towner, and anybody who's carrying that much cash, you just have to be up to no good. I suspect that this is drug money, and I'm going to seize it. If you want to stick around, I might have to rethink about whether it is I'm going to arrest you. But if you sign this document right now, right here by the side of the road, that forfeits your right to these funds, I'll just let you go on your merry way. Now, regardless of what you think about civil asset forfeiture, that is an appropriate practice. And one other thing that I would focus on, and this has been well documented, is that even if you believe, let's assume you are a major supporter in the war on drugs, and even if you believe that depriving drug dealers of their facilitating property and ill-gotten gains is a very, very laudable goal, the profit motive warps law enforcement's priorities. So for instance, there have been big documentations about small towns that are in between a border where drugs are going to be coming in and a major city where the drugs are going to be sold. And what you find is a small contingency of law enforcement officers who are watching cars passing through that hamlet that they suspect are carrying drugs. And they will note the information about the driver, they will note the information about the license plate, and they will let the drugs go through. And then those drugs are sold on the streets of whatever that city is, wreaking the havoc that such sales cause. And the reason they let that go through is they have a far larger contingency of law enforcement officials on the other side of the highway who are waiting for that car to come back, and then they will seize the cash. Now, if you care about stopping drugs being sold to kids or adults in these cities, I don't care who you are. The focus should be on stopping the drugs and catching the guy with the drugs, not grabbing the cash after the drug transactions have been consummated. So now let's get a little bit to what if law enforcement officials were here and talking to you, they would say, look, law enforcement authorities, they need civil asset forfeiture because it allows them to seize money and property from drug dealers and other bad guys, and these are tight budgetary times, and they need these forfeiture funds in order to continue with their efforts to fight crime. What would you say to that?
I would say it's the responsibility of state legislatures and local governments to fund police. If there is a funding shortfall, if there's a problem, local governments should deal with that. And you were talking about like how they kind of they're letting drugs go through and just looking for the money, basically. But that's the problem with this. Is like it does it does not promote, it's counterintuitive, but it does not promote public safety to use civil asset forfeiture, because police become revenue collectors rather than doing their actual task of protecting and serving the public. There was a study that came out of, I think the Drug Policy Alliance, it was a couple months ago, on Southern California, around Los Angeles. They looked at some of the cities around that area, and how they were using federal civil asset forfeiture funds through the equitable sharing program to basically just fill budget holes. Like, they would get $140,000 in equitable sharing funds.
Do you want to take a moment and explain what the equitable?
Yes, I'm sorry. So the federal government, the Justice Department has a program. It's the equitable sharing program, where the local police, state and local police, can send property seized up to the federal government for adoption, a federal agency, when they're working in coordination with, and they'll receive 80% of the proceeds back. So in a lot of states, they have some restrictive forfeiture laws. Unless there are prohibitions on equitable sharing participation, they can circumvent state restrictions through this program. And that's very problematic. And there have been some reforms through that, but they don't go nearly far enough, at least not yet. And I'm sure that'll be discussed in the next panel. But no, they would get $140,000 in equitable sharing funds, and then the next year their budget would be cut by $140,000, and they would just plug the holes with the money they got through equitable sharing. There was a city attorney in Las Cruces, and we were talking about some of the transparency issues. There are schools that police officers go to basically teach them how to steal people's stuff. And it's kind of concerning. There was the city attorney in Las Cruces was basically bragging like we could own the city. It's in the New York Times story, I think, from October of last year. And then the sheriff in Columbia County, Missouri, who said it's pennies from heaven. This is how they view this stuff. And without restrictions, without changes, it's just going to be, there'll be more abuses, there'll be more horror stories, there'll be more. It's not just the structuring cases that people are losing their businesses. There was a guy in Staunton, Virginia, who had $18,000 stolen from him. He lost his business because he fought. To his credit, he fought it. He won with IJ's help, I believe. But he lost his business in the process of it. So this is pernicious stuff. It needs to, and we have to change it.
Grover, what about you? What would you say to the law enforcement officials?
Look, the IRS is very good at stealing money and giving it to you. You're not allowed to freelance. There are other parts of the government that are going to take people's money. We ought not to be adding to that. We ought to monitor how the IRS does it, or the state tax people do it, but not open this other thing. The British Navy used to have a rule that if you captured a French ship, the captain got to resell it and got the lion's share of the value of the ship, which was, and then the guys on the crew got it as well. When they did privateers, they would get to keep the stuff they stole. Then when the war ended, from 1700 to 1725, there weren't any wars going on, so all these guys became pirates, which is when we had, this massive pirate problem, which were just the guys who kept going under the previous rules that the government had set up. You can go grab other people's ships and steal their stuff, and that's legal. And when the war ended, they just kept going. I wonder how much of this cash that's confiscated actually ends up even in the police, the sheriff's office, between when the guy takes it from your car and when it shows up. The guy had $100 on it. It's amazing. It's all yours, Sheriff. So I think these numbers are not necessarily what we're looking at. I think it breeds all sorts of awful corruption. People have been doing this for too long. It's like, congressmen who did earmarks long enough just became corrupt people because this corruption was legal and encouraged. And stopping it will gives you better congressmen. One of the reasons I always liked Boehner was he never did earmarks, just even when you were allowed to be a pirate. He didn't do earmarks when it was okay. And getting rid of this will give us much more honest policing. And we'll do a lot to improve the relationship between law enforcement, prosecutors, and citizens than the challenges we have right now.
Well, what would you say?
when you start reading the literature about forfeiture, one of the first things you run into is the money that is spent on fancy cars for the police chief and conferences in sunny places that everyone gets to go to, and in general, the obvious misuse of money. I think we should remember that even if it were all being used for quote-unquote legitimate purposes, what they have just confessed to when they cite this as a reason to have the law is a separation of powers violation. The power of the purse is entrusted to the legislature for very good and sufficient historic reasons. And when we allow the power of the purse to move into the executive, thus bypassing the legislature, you get a phenomenon that is well known aside from the forfeiture situation. And I've mentioned before that this is an issue where the general business lobby concerned about business and the law ought to be converging with many of the people in this room, because at the Chamber of Commerce, they understand very well the dangers when a state attorney general, for example, does settlements of various business prosecutions. And as AGs in California and New York have done, rather than hand it over to the general fund for the legislatures to appropriate, passes it out to favored agencies or universities or private groups. You have both Schneiderman in New York and Locker in California having passed the money on to political allies in the private sector to do supposedly good things with. And the business community understands intuitively that allowing a flow of hundreds of millions of dollars that does not have to go through the legislative process but can be given out as favors to friends is going to land them in a lot of trouble and higher fines. I hope that if they're not represented here today, that they soon are, because it is really the same struggle.
I would add, those are all excellent points. I'd add a couple of things. If a law enforcement official were here, I would sit there and say, look, if you want to go after the assets of bad guys, I think that's fine, but you're focusing so much on the property, it does lead to real unfairnesses. So Walter was talking before about structuring cases where perfectly legitimate businesses who actually have reasons why they're engaging in cash deposits or withdrawals of less than $10,000, totally unconnected with the desire to avoid filling out a currency transaction report. A lot of times insurers, for instance, this will be a cash business located in a perhaps a sketchy neighborhood that's going to go and make bank deposits. They know that there's a possibility that they're going to be robbed, and their insurer will only insure them up to $10,000 for any kind of theft. Now, any rational business person at that point would sit there and say, look, there's a possibility I might get robbed. I'm going to be carrying $8,000 or $9,000. I can be insured for that. If I carry 15, then I'm not going to be insured for that final 5, so I won't carry the 15. Also some of the other, we talked a little bit about innocent donors. So Walter also alluded to this, which is you have homes that are owned by parents or grandparents, and totally unbeknownst to the parents or grandparents, a young adult or juvenile living in the house is selling small amounts of drugs to an undercover police officer or an informant from the front porch. And the police come in and say, your entire home was a facilitating property of this drug deal. We're going to seize the entire home. Or if you are, I'm not meaning to be sexist, but you're a jilted wife, and your husband takes the car out for an evening and goes and visits a prostitute. It's your car. You titled the car, you paid for the car, but all of a sudden they go and they seize the car because it was used as a facilitating property. It transported you to the place where you engaged in this illicit and immoral transaction, and all of a sudden it becomes government property. Before I turn to questions from the audience, let me touch on one more matter. So the Supreme Court has considered constitutional challenges to a lot of these laws. They have in fact accepted, granted certiorari for a criminal forfeiture case next year about whether or not assets, you're entitled to a hearing about whether or not you can use those assets to pay for a private attorney, or whether the government gets to freeze those pending trial. But the civil asset forfeiture cases that the Supreme Court has considered have not gone well for the challengers. They have rejected these challenges time and again and have upheld the constitutionality of these laws. So the government would say, look, This is civil asset forfeiture. And a lot of these procedures that are involved here, proving something by preponderance of the evidence, requiring the owner to bear the burden of proving innocence, those are all sort of standard civil procedure type standards. So what's unfair about that? What would you say?
Because the burden of proof rests on the property owner, and it was interesting you were talking about the story about the prostitute, and that was actually a Supreme Court case in 1996.
Yes,
That was Bennetts, right? Yeah, v. Michigan, and the Supreme Court held that the wife's her due process rights had not been violated by the seizure of the car her husband had engaged in fun times with a prostitute, and the car, and the police seized it because it was used in the commission of criminal activity. And I don't know if he was ever charged. I don't remember all the backstory of it. It just came on my radar recently. I was trying to do some reading up on the Supreme Court and on this issue. But I mean, we go back and we look at this. This was British Admiralty law. That's where all this started, and it was the United States adopted it, and then the first ruling I think on it was back in like the 1830s or something like that. But we're talking about, I mean, an explosion in the use of civil asset forfeiture. This is not. I actually have some numbers here. It's like. So in 1986, it was $93.7 million. That's how much the federal government had. Now it's in over $1 billion in 2008, and it's been over $1 billion in subsequent years. So we're like, the due process being tossed completely out the window, so people can, the government, the law enforcement can reap the windfalls of this. And I don't see how I realize the Supreme Court, obviously, yesterday was an indicator of this, but the Supreme Court, I don't see how they can look at that and say that that's due process. I don't see how anybody can say that's justice.
What would you say to that?
Recently, we've been reminded not to count on the Supreme Court or the courts to defend or define our rights and what's constitutional. We did reasonably well on the Second Amendment, even with some court decisions, but those court decisions all followed political victories. We changed 12 million Americans with concealed carry permits, okay? Makes it, the courts followed not the election, but the culture, and the fact that we've decided we're going to be an armed society instead of not. The Second Amendment was pretty clear, but that's not what came in. I think this strikes me as completely unconstitutional by any means. However, we're going to pass this state by state, and we're going to get federal laws, and then 5 years from now the Supreme Court will go, well, as we've always thought, this is completely unconstitutional, and there's this right not to have your property stolen, which, since everybody else recognizes it, we'll get on too. I would be delighted if the courts strike it down, but I actually prefer a 50 or 57 state approach where we go out and have this debate like they did in New Mexico, where the tremendous success there. They talked about it on talk radio, they talked about it in the legislature. It's very difficult, I think, to ever take back the victory in New Mexico because it was so discussed. It wasn't a bunch of judges coming out and no one was paying any attention and somebody telling you there's this new law in town. It was, we collectively decided this was wrong and here's why, and the newspapers talked about it. So yes, we should go through the courts, and I understand somebody wants to get their money back and not wait for the legislature to meet, going to court. But I do think at the end of the day, this will be a political victory against statism rather than a judicial victory.
Walter?
I'm trying to think of what Justice Antonin Scalia would say if he were here today. Now, he couldn't be here today. He's I think, still reading his dissent in the marriage case, which was decided before. But if he were here today, he would point to the historical background and the absence of a provision specifically providing a remedy for this, and he might go into the history about there is no remedy in the Bill of Rights, perhaps because it was not a common abuse then, or perhaps because people had different views of the dangers. But Scalia would not say, and therefore there should not be any remedy. He would say, and therefore your remedy must be legislative. And when a crying outrage comes up, and the outrage, as Jason mentioned, has been impelled by the fact that a formerly rare and unusual bit of law has turned into a major phenomenon, moving much more money around, then the will to reform is there. And some of it will come out through the judicial system because the courts will be pressed more to decide on various questions that have not been posed in quite that form before. But as Grover said, much of the energy has to be put into the legislative process. I think that's absolutely right.
Yeah, I guess I would say that although it is civil asset forfeiture, even the Supreme Court has referred to this process as being quasi-criminal. And for all intents and purposes, it is a criminal proceeding. It involves law enforcement officials who are seizing these assets. They're the ones that are providing the evidence, and I think Walter is exactly right. It's that the Constitution provides just a floor, not a ceiling, and therefore this is a target-rich environment in terms of legislative efforts. I would note, though, that there are some judges, I know from Texas, for instance, Associate Justice on the Texas Supreme Court, Don Willett, has recently said perhaps there's time to re-examine the constitutional issues involving innocent donor. And so because of these abuses, there are judges who are taking a second look at this. But with that, let's open it up to any questions that you might have. Let's start right over here. If you could please actually identify yourself and your affiliation and then ask your question, that would be great.
Eric Olson of the Charles Koch Institute, and I see disturbing parallels between IRS structuring seizures and Operation Choke Point, which was designed to discourage bankers from doing business with gun sellers, payday lenders, other groups that they didn't like. And so, could you maybe describe the incentives on small businesses that might very strongly prefer to use cash deposits, but when they see other small businesses being, in some cases, literally put out of business, what does this do to sort of their operations? And is this extra legal? Because if the IRS, presumably, if they had the authority to ban these kinds of transactions, wouldn't they?
I think that's a fascinating connection with Operation Choke Point and the set of regulations that preceded it, called Know Your Customer regulations, in which banks were saddled with a new regulatory obligation to investigate, to some extent, the people doing business with them and send reports to Washington about supposedly suspicious activity, not all of which would actually strike us as suspicious. Now, several things are going on, including the banking system being conscripted into being a surveillance part of the regulatory apparatus, both for tax purposes and for enforcement of countless other laws. But you get to these specific compliance dilemmas both for the small businesses who find that the bank is not on their side and often cannot tell them why it's doing mysterious things, and of course compliance dilemmas for the banks and other financial institutions. Currently happening in the Southwest, for example, is banks dumping long-time business customers in places like Nogales, Arizona, because the pressures from above on scrutinizing customers very intensely means that an ordinary banking relationship with an ordinary merchant simply becomes so high overhead for the bank that it's worth cutting it off. You see some of the same things with FATCA, the International Banking and Tax Compliance Law, which requires foreign banks to keep track of expatriate Americans. So it is long past time that we have a debate about how much territory law enforcement has tried to seize, and when we can get back some of our own privacy as well as some of our own regulatory sanity.
I guess I would say this. There are some differences with Operation Choke Point. Operation Choke Point is clearly targeting particular industries because the government doesn't like what those industries are doing. And structuring laws are not targeting particular industries. So the reason, there's nothing illegal about withdrawing cash, depositing cash. The reason why structuring laws were put into place is because drug dealers and terrorist organizations and other people who are engaging in other forms of organized crime typically have to move very large amounts of cash. And the government wanted to make it very, very difficult for them to move large amounts of cash. And if people were moving large amounts of cash, they wanted to be able to go and ask questions, identify these people, and do whatever it is that law enforcement does. So Walter is correct that structuring laws were put in place in order to co-opt or get financial institutions to be part of government surveillance. And what the structuring laws say is, so if a drug dealer was previously depositing $50,000 in cash and he realizes, or it comes to his attention, that a record is being made of that he's going to start dealing in amounts just under $10,000 in order to avoid having that currency transaction report filed. In Dennis Hastert's case, the allegations in the indictment, of course, are just allegations, are that he was withdrawing very, very large amounts of money in order to pay somebody off. That generated a currency transaction report. That, in turn, generated what was no doubt a very uncomfortable visit from FBI agents asking about the nature of these transactions, what they were for, and that after that conversation, former Speaker Hastert started withdrawing amounts under $10,000 for the purpose of avoiding the filing of those reports and another unpleasant visit from FBI agents. So the similarity involves is that there are financial institutions at the center who are feeding information to the government that is leading to government action. But Operation Choke Point is in fact targeting particular industries. The theory behind structuring is to try to target people who are engaging in illegal conduct. Of course, then, when you have innocent businesses that are not involved in that, one could argue that they are perhaps violating structuring laws, but that it's a very abusive form of law enforcement priorities to go after those businesses. Other questions? Yeah, please.
Ben Riddell, I'm with the ACLU of Illinois. In our state, we're at the very beginning of a legislative effort on this topic, and our organization is fully on board with our philosophical criticisms of this practice, and what we are seeking to do to aid our legislative effort is kind of build a narrative to support that. And I was wondering, as far as documenting this practice, have other people seeking to do that been successful in obtaining public records, and how transparent is it? How able are we to determine, to get data and facts about how much law enforcement, how many forfeitures they're doing, how much money they're collecting, and try and lead us to some of the horror stories that will support our case that this is a bad practice?
The state transparency requirements aren't really followed. They have them. Jorge and I actually just wrote an op-ed together on the Georgia's new civil asset forfeiture bill. Being someone, I'm an Atlanta resident, so I have a vested interest in this because, they didn't really reform anything per se, but they did heighten some transparency. But before the law went into effect, there was effectively no transparency. I think IJ had a report on Georgia's laws, I think 2011, 2012, and only like 50 counties reported back. Georgia has 159 counties, and then other jurisdictions as well, because municipalities have their own police forces. So most state transparency laws, unless they're just not enforced, and law enforcement typically doesn't file stuff with it. And there have been some pushes in other states to heighten the transparency. New Mexico's new law has some transparency requirements that I'm sure, because of the strictness of the law, how good it is, I'm sure they're going to be effective. But other states that are just kind of pushing tepid reforms, I don't really expect much.
Are these FOIable?
You would think so.
Have people had success doing a Freedom of Information Act on that in the state?
That's part of my question about whether people have had success in other places where they've done that. Because right now what we're doing is we're reaching out to the defense bar and trying to get narratives that way, but we haven't started issuing FOIAs, and I wonder if it's wise, or if we think that's gonna lead us where we need to go.
That was one reason I was mentioning Georgia, is because, and I should have mentioned this when I was talking, but they tried to do FOIA requests, and they couldn't get anything. I think they even tried with Atlanta. There was actually, I think this was the center of a lawsuit that IJ filed against the city of Atlanta to try to get information, because they had no information. And so, unless there are strict requirements, I doubt you'll get much. You may get something, but you won't get much.
This should also be seen as an accounting issue of tracking money flows and inventory flows, which good practice in a state should require without having to put anyone through FOIA.
But also, if you're in a state like Virginia, where the governor doesn't necessarily want to reform this process, if the first request is, let's get transparency on how big it is, I think it's harder for the prosecutors and the sheriffs to come and say, no, 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 veto that bill, than it is to say, please veto a bill about which there's very little information. So I would suggest in any state, if you're thinking to try and do New Mexico, that you should at the same time have legislation to keep it completely, to make it completely transparent. So you don't have to FOIA it, but they has to be online for people to see. Then it'd be nice to have both, but if you only get the transparency first, next legislative session, I think it's a lot easier to make the case.
I have no particular opinion about that, other than to say that one of the nice things about FOIA is people know you're watching, and you should be prepared for the fact that you're not going to get the information, you're not going to be very forthcoming with it. It may take a little while, and it may end up resulting in litigation. But the fact that people know you're watching is worth something, and when somebody comes in and starts talking about the scope of their forfeiture program and they weren't very responsive to you, you'll be able to sit there and say, oh, we'd like to see those records. So it helps you build a political case. I saw a hand in the back of there. Yeah, back there.
USA is turned into the Wild Wild West.
Can you speak up just a little bit?
The USA is turned into the Wild Wild West. The USA, the judiciary, the government, and elected officials are not being held accountable. And we're not shaming them and exposing the corruption of ignoring the rights of our citizens. And with everything that's going on, the one thing you've said is there is no place for anyone to go to hold anybody accountable. And I'd like to know where you would suggest that someone goes to hold a judiciary person, a government person, or an elected official, that they aren't ignoring the problem, because if they don't ignore it, then they could maybe get caught. Right now, we don't have any oversight. Our media is not doing it. And I mean, if you have a comment as to where someone can go.
I would send you to freedomworks.org. The New Mexico law was the first time we really engaged uncivil asset forfeiture. We sent over, in 72 hours, we sent about 5,000 phone calls to Governor Martinez's office, like urging her to sign that law. And she responded, she signed it. I mean, we have 6.9 million activists. We plan on engaging in any state we can on these issues. So it's one thing I've said about Pennsylvania and Michigan, because there are reforms that have been introduced there. Like you're gonna hear from us. You're gonna hear from the grassroots. We're gonna hold you accountable.
In fact, the press has done some very good work, and the New Yorker magazine, for example, did an excellent expose of the highway robbery in, I believe, Tennessee and Texas, rural counties. The Philadelphia newspapers have done some excellent investigation of the outrageous situation of forfeiture in that city, perhaps the worst in the country. But the questioner raises a very interesting point here, which is, once the press has done its job and you've had these abuses exposed, what happens to the people who are committing them? And often if you go back a year or two later, you find that they haven't even lost their job as county sheriff or police chief, let alone any more severe consequences. That the patrolmen or policemen have all kept their jobs too. And so that part of the situation has been very discouraging. There have been very few consequences, even for the best documented of the horror stories.
I would say that I also do think that the press has done an okay job on this issue, and there are grassroots organizations. So Jason touted his publication, one which you all got here, Arresting Your Property. If you look at the back of that, so this is something Heritage Foundation did, but it's been endorsed by a broad array of groups, right, left, and center. It's very, very rare that you will see, the Charles Koch Institute endorsing the same thing that the ACLU is endorsing. These are prominent national organizations, and in some states, local state think tanks. And I would also say that there are some elected officials who are paying attention. I happen to know, I won't out him, but there's at least one elected official in the room today who is looking very seriously at this issue. I applaud him for doing that. it's tough because law enforcement authorities who are under budgetary pressure view this, and this is only very slight hyperbole, as an existential threat. And they will come out in force, and are coming out in force, to resist any change to civil asset forfeiture laws. And I think that keeping up a steady drumbeat and helping to stiffen the backs of those legislators who are prepared to look at this issue and try to address this in a sober, fair manner would be very, very helpful, but not easy to do.
I'd like to make it clear, I was in no way suggesting that any grassroots was not doing their job. I mean,
Right.
everyone in a grassroots situation is working really hard with little give and back.
No, that's fine.
And I want to make sure that
No.
in any way.
No offense taken, I can assure you. All right, Cardi, had a hand
One
up.
second, one thought. When you've got something like Virginia where there was all this pressure from sheriffs and prosecutors, I wonder if in the legislation you said this is going to be illegal in the future. You're not going to be able to do in New Mexico. And we're not going to be prosecuting anybody who turns the money back within the next 3 months. So you'd say, I don't know whether you have to do that to get it past the sheriffs, but some sort of, I don't know, there may be a deal where we're not going to go back and put you in prison for stealing people's property, but you can't do it anymore.
So I had a hand up over here, and then I saw there was another one here, so let's go.
Yeah, Howard Wooldridge with LEAP, Law Enforcement Against Prohibition, retired detective. And I was a property room officer in a department in Lansing. And so I'm intimately was involved with the seizing the funds, putting them in the bank, selling the cars, et cetera. We've all been beating up on the police, rightfully so. But I also know that my prosecutor, when I left law enforcement in the mid-90s, was receiving 10% of everything seized in the county. And he was asking for 20 for his role in terms of when somebody did plead not responsible and they did have a hearing, he said, I need 20%. My question is, across the nation, I expect a little more out of prosecutors who are better educated and more aware of what's going on in the world. Are prosecutors almost as bad or as bad as police officers in saying, don't change nothing? We saw at the Grassley hearing about 2 months ago where the head of my old union, the FOP, Fraternal Order of Police, said to the senators, it's about the money. We need the money. But my question is, are prosecutors as bad as law enforcement organizations?
I don't know if you've followed anything out of Pennsylvania or Philadelphia. The prosecutors there are really driving it. So apparently, like the process, you actually may have to go to a hearing up to 10 times to get to plead your case, and you're not before a judge. You're talking to prosecutors and lawyers. I don't know if you've seen John Oliver's segment on civil forfeiture. He talks about Pennsylvania or Philadelphia, and this particular room 423 in the Pennsylvania or Philadelphia City Hall. If you haven't seen this, you should watch it. But no, in Philadelphia, definitely prosecutors are driving it.
10%, 20%. When you read in newspaper articles about particularly corrupt dictatorships around the world, there's always some relative of the dictator who's known as Mr. 10% or Mr. 20%. Okay. We don't need to do that here.
I think you're exactly right that they are more sophisticated actors who should know better and should be held to a higher standard of argumentation. And they're also a little bit more politically answerable. In Maryland, we elect our county attorneys in various places. You know, Lynn Abraham, who ran the DA's office in Philadelphia, was a politician as well as a law enforcement official. And that plays both ways. On the one hand, contributions from the FOP and others. On the other hand, a real opportunity to make this an issue in electoral races, which may be hard to do otherwise.
Let me say this. So I agree with everything that was said here, but there are going to be prosecutors and there are going to be law enforcement officials who really are motivated to do these cases, not because they're just looking to fatten their own pockets, because they believe that they're doing right by depriving bad people of their assets. And these are also hardworking public officials who are facing tight budgetary times. And they probably use a lot of these funds for perfectly legitimate law enforcement reasons. But that aside, there is still a lack of transparency, and there are still incentives then that sort of warp one's perspective. And I share the same concern. I forget it was Grover or Walter, I guess it was Grover, who said, you know, gee, when you're doing the highway seizure, how much of that money is actually making it back into the property room? And so all of those abuses are there when you have an ability to get your hands on large amounts of money totally outside of the legislative process. But I don't want, you know, to leave the impression that, you know, everybody who engages in civil asset forfeiture is just looking to get a jacuzzi and isn't, you know, motivated by the right thing of seizing assets from really bad guys and using it so that they can engage in more legitimate law enforcement functions. That's all. There's a hand up over here. Yeah.
Hi.
She's bringing a mic.
Hi, Bob Penzabek. I'm a lawyer in the area. I've done some work on the issue of overcriminalization and civil asset forfeiture. And I guess we mentioned that at the state level, there are a lot of things being done. There are a lot of these great state policy networks, you know, Mackinac, organizations like that. But I think, you know, we spoke a little bit about adoption and how, you know, you can work around the state and local regulations. I guess my question is, based on what any of you might know, what is the likelihood of something like the Fifth Amendment Integrity Restoration Act passing? I know Senator Grassley is very sort of pro-civil asset forfeiture. Is there some receptiveness to changing that?
Actually, Grassley wants to like burn it to the ground. Yeah, no, the hearing that he referenced back in April, it was on tax day. You should go back and watch that, or at least read his opening statement, because his opening statement was just, it was like awesome, just amazing. He was just blasted it.
It's mandatory minimums he has some trouble.
It's mandatory minimums he has problems with, yeah. But he's actually good on civil asset forfeiture. He was working on his own bill. We've seen the draft version of it. We liked it, but mandatory, like sentencing reform is kind of like dominating discussions on the Hill right now, at least in the Senate. So, and all the momentum, we were expecting a bill by the end of April and it never came out. So that's kind of where we're at right now. But on the Judiciary Committee, the biggest problem we're going to have is probably the Democrats and Sessions, based on what we've seen.
Well, that was a very interesting hearing, and I agree with what Jason said. The one person who was standing up there and saying that you should not do anything to amend civil asset forfeiture was Jeff Sessions of Alabama. My understanding, purely in the for what it's worth categories, that there is a bipartisan group of senators that are meeting at the member level to try to work out their differences and come up with some kind of meaningful reform. But where that's going to go, of course, remains to be seen. Any of you guys have anything to add to that?
I would add on equitable sharing and the use of federal enforcement to get around state rules. I'm not sure anyone has mentioned that Attorney General Eric Holder did hand down some new guidelines. They are not the panacea one might hope, to quote my own website, overlawyered.com. Quote, something like 86% of the loot that state and local law enforcement agencies receive through federal forfeitures will be unaffected by Holder's new policy, unquote. Nonetheless, it's an important start, and it raises the visibility of the issue. For so many of these questions, raising the visibility of the issue is the most important first step, because a lot of the support will fall into line once people understand the issue.
Yeah, the department has said that they're in the midst of a top-to-bottom review on this issue, and it's a good thing. My guess is that they're doing it in order to try to hold off a legislative effort that would more directly impinge on their future actions. There's a paper that's out front that I wrote on civil asset forfeiture in general, but it also discusses a number of the changes to departmental policy that Walter just mentioned. So you may want to pick that up and read that if you are interested. Any closing thoughts before we finish our panel?
Yeah. The late Joe Sobran said anything called a program is unconstitutional. And equitable sharing program, I think, is a triple header here. If it's got equitable sharing and program in the title, it's unconstitutional.
Anything else?
We've seen how energies and momentum that started out mostly in the drug war area have expanded to unrelated business regulation, unrelated individual forfeitures and seizures. And I could go on about other examples of that, but let me just leave with one closing one, which is in January it was revealed, and there was a flap in the newspapers, that there is a law enforcement program to capture license plates, not just at the border, but all around the country, and to share them in real time, not just after a crime has been committed. Share them in real time. And civil libertarians got kind of upset, and I didn't blame them for doing so, but once reporters began asking about how did we get this program that had never been revealed to the public, it turned out that one email written in 2010 said the primary purpose of the program was asset forfeiture, and that although the program had been started by and was run by the Drug Enforcement Administration, its data is increasingly shared for investigations unrelated to drugs, because once they've got the technique, once they've got the surveillance, once they've got the information, the rest of the government wants in.
Yeah, just keep following what we're doing at FreedomWorks. FreedomWorks.org/justice for all is where all of our criminal justice reform stuff is can be viewed, including our asset forfeiture posts and publications. But for us, we're paying attention. This is all being, I think Grover said this earlier, the states are really leading, and we're really happy to see the momentum. We hope to see a lot more New Mexico laws getting passed in state legislatures. But we're watching. We're going to be looking where we can engage and drive calls or drive our activists to get involved. And we're just really excited to see the momentum, and especially excited to see the crowd here today to show that people actually really care about this issue. So thanks for being here.